Hello from the Authors Guild Foundation. We're here for a special educational webinar on publisher bankruptcy, what authors should know. This is a bit of a rip from the headlines episode. In particular, we're going to be hearing about the current situation with Albert Whitman and Company, a long-running children's book publisher. Our guest today is Marc E. Hirschfield, who is assisting the Authors Guild with the bankruptcy proceedings at Whitman. Thank you to the National Endowment for the Arts and our donors whose support allows the Authors Guild Foundation to put on free public educational programming like this for any writer who needs it. The foundation educates and supports all authors in the U.S., publishing in the U.S., while the Authors Guild is a membership association. You can find out more at authorsguild.org. We're pretty well known for reviewing contracts and other legal assistance, but we also get involved with bigger issues like this as needed, things that affect larger groups of authors. Also on hand is our Director of Policy and Advocacy, Umair Kazi, and Staff Attorney Kyle Maxey. Thank you, Umair and Kyle, for being here. They'll be looking at the Q&A box. Those in the audience, feel free to submit questions in there. Thank you to all the questions you submitted in advance as well. And Marc Hirschfield has a little talk, but mostly about Whitman and about how all this works, and we'll answer the general questions toward the end. Marc's been recognized by Best Lawyers and New York SuperLawyers for bankruptcy litigation. He focuses his practice on bankruptcy, business restructuring, creditors' rights litigation, and debt finance. He has 30 years of experience as an attorney, and he's also a court-certified mediator. Marc, I'll let you take it over from here, and I'm interested to hear what you have to say. Thank you.
Great. Well, thank you so much, Johnny, and thank you everyone for attending today. So it looks like a really good turnout, so I'm very pleased to see that. As Johnny said, my name is Marc Hirschfield. I've been an attorney here in New York City for more than 30 years, and I've spent my career doing various bankruptcy cases. Some of the largest and most complex cases ever to have been filed, including the Bernie Madoff Ponzi scheme. I was one of the lead lawyers there. I'm currently involved in Purdue Pharma. I was involved in the Rockefeller Center bankruptcy during the 1990s, Enron, Lehman, just to name a few. So those are sort of my experience. I've also been involved with less complex bankruptcies like the one we're talking about today, the Albert Whitman case. That's a special kind of bankruptcy. It's a subchapter 5 bankruptcy. We'll talk more about that in a few minutes. So in terms of what I'm going to talk about today, I'm going to talk about sort of the basis of bankruptcy. What does bankruptcy mean? Chapter 11. I'm going to spend some time talking about subchapter 5. I mentioned that just a few minutes ago. It's a special kind of bankruptcy that came into existence about 5 years ago. I'm going to talk specifically about what's going on in the Albert Whitman bankruptcy and what creditors there should do. There's a meeting on Thursday called the 341 meeting in the Whitman case, and I'll talk about that as well. And finally, I do want to save some time at the end to answer your questions. So please feel free to submit some questions in the Q&A. I'm told that the folks from the Authors Guild will sort of be monitoring those, and either they'll jump in during the talk if something's relevant to what I'm saying, or else we'll answer those at the end. So please feel free to submit your questions. So I'll start off by saying sort of what is bankruptcy? Bankruptcy is a process by which a company or an individual can adjust their debts. So a company, in this case, a company, got into financial trouble for whatever reason. They can't afford to pay all their creditors with certain operational issues that need to get dealt with. And they can file for bankruptcy to help facilitate those resolutions. Oftentimes in a bankruptcy, what happens is claims get paid at less than full, and the debtor comes out the other end continuing to do business. So the goal of bankruptcy, Chapter 11 bankruptcy, is to come out of the bankruptcy as a going concern. That is, you continue to operate post-bankruptcy. Sometimes, however, bankruptcy could wind up leading to a liquidation or even a sale. So in many cases recently, over the past 10 or 15 years, a company will enter into bankruptcy with the goal of selling its assets to a third party, and that's the way that they sort of come out of bankruptcy. Rather than reorganizing themselves, coming out as a standalone entity, they'll instead sell their assets to somebody else. Currently, there's no plans that I know of to sell an Albert Whitman, but that's certainly always a possibility. So how does a bankruptcy start? A bankruptcy starts when a company files a bankruptcy petition with a bankruptcy court. And that date, when that happens, is called a petition date. And that's a very important line in the sand. It splits what happened pre-petition, meaning before the bankruptcy was filed, from what happens excuse me, post-petition, which is after the bankruptcy was filed. And there's very different consequences to those two situations. So pre-petition is, as I said, what happens before the bankruptcy. And when you file the bankruptcy, something called the automatic stay comes into effect. As the name automatic stay implies, it's automatic. It happens by operation of law, Section 362 of the Bankruptcy Code. The minute the bankruptcy petition is filed, the automatic stay comes into effect. And that, as a general principle, affects all creditors because it prohibits creditors from doing many things, including trying to collect any pre-petition debt from the debtor. So just hypothetically, company XYZ goes into bankruptcy on May 25th and May 27th today, and you were owed $1,000 from yesterday. That debt is pre-petition debt, and the automatic stay would prohibit you from trying to collect that debt outside the bankruptcy. Now, fast forward 5 days, and something comes due on June 5th. That is post-petition debt. That's quite different. Any kind of post-petition debt will get dealt with in ordinary course, meaning the debtor would pay it as they would, although no bankruptcy had happened. Pre-petition debt, my $1,000 was owed from last week in my example, that gets dealt with in the bankruptcy itself. And as I said, the automatic stay would prohibit anyone from trying to collect it. And there can be harsh penalties if someone did violate the automatic stay. So if you commenced a lawsuit, sent invoices, did things that were sort of considered violating the stay, you can get sanctioned for that. Generally, if you make a mistake and happen to submit an invoice, not a huge deal. They'll just let you know that it can't be paid. But if you were to continue and try to, as I said, commence a lawsuit or do other things that would be considered a violation of the stay, you can get sanctioned. So really, bad idea to do that. You should just deal with the bankruptcy and have the debt dealt with during the bankruptcy. So unlike many other countries around the world, in the US, when a debtor goes into bankruptcy, a Chapter 11 bankruptcy, they continue operating. In most parts of the world, a bankruptcy, when it's filed, means the company immediately shuts down and goes away. Here it's different. The debtor in a bankruptcy case here, a Chapter 11 case, continues to operate going forward. Now, it is under the supervision of the bankruptcy court, but the debtor remains in possession. It's called a debtor in possession. They continue operating post-bankruptcy under the supervision of the bankruptcy court. What does that mean? It means that in certain cases, the debtors can do things as they did before the bankruptcy, continue operating, continuing to sell their goods, do whatever they did pre-petition. In certain cases, they need to seek bankruptcy court approval to do certain things. Things that are outside the ordinary course of business, that's a term of art, do need bankruptcy court approval. So if they were to enter into a settlement, for instance, with someone, that under the bankruptcy code would require bankruptcy court approval. And there's a process by which the debtor would file a motion with the bankruptcy court, and there'll be a hearing ultimately where the bankruptcy court would consider that relief. So again, going forward in the bankruptcy, ordinary course, meaning things that they did every day before the bankruptcy, like selling goods, like entering into new contracts in certain cases, those proceed as though there were no bankruptcy. But other things that happen do need bankruptcy court approval. So in a Chapter 11 case, as I mentioned, the goal is for the debtor to prepare and file a plan of reorganization. The plan of reorganization will detail how the company will pay their pre-petition debts and to what extent. So it gives a lot of detail. They usually can be quite thick. In some complex bankruptcies, they could be a couple hundred pages thick. In a case like Albert Whitman, I would expect it to be much shorter, probably 30 or 40 pages at most, maybe even shorter than that. But the bankruptcy plan will detail what's going to happen to the company, what's going to get paid and how and when, and then creditors get to vote. So the court will approve in an ordinary Chapter 11 case something called a disclosure statement, which will then be sent to creditors, which will detail what the plan provides. The disclosure statement in a regular Chapter 11 case is an even longer document that spells out, supposedly in plain English, but oftentimes not, what's going to happen under the plan. And creditors then get a ballot, and they get to vote on the plan. And if a certain number of creditors vote yes, and the plan otherwise meets legal requirements, In that case, then the plan will be confirmed. Once it goes effective, these are all terms of art. Confirmed meaning approved by the bankruptcy court. Going effective means that it basically goes into effect. Once the plan goes into effect, creditors will get paid. Now, they said oftentimes bankruptcy plans will pay less than par, less than the full amount. So you may oftentimes hear that the plan's paying X cents on the dollar. So 10 cents a dollar, meaning you get 10% of your claim paid. It could be 20 cents, 20 cents a dollar, 5 cents a dollar. Usually, unfortunately, for creditors, the amount that gets paid to creditors is usually relatively small, usually 10, 20 cents at most. And that can get paid in one lump sum upon the bankruptcy case concluding, upon the plan going effective, or more often it's over time. The plan could provide, let's say the 10% plan, a 10-cent plan, it could provide, just as an example, that 2 cents get paid upon confirmation, and then the rest gets paid later over the course of 3 years. So every 6 months you get paid another couple cents until 3 years go by where you've gotten paid the full. In my example, 10 cents. Again, every plan is different, so it'll be important, always important, and certainly important in the Whitman case to see what the plan is going to provide. So as I said, it's also possible for a debtor to, rather than propose to come out of bankruptcy itself, to sell its assets. And many times there'll be contracts that may prevent the debtor from selling certain assets. Generally speaking, those provisions are not effective in a bankruptcy case to prevent the sale. The bankruptcy code will override those contractual provisions and allow a sale, even though the contract says you couldn't sell it. There are certain exceptions, and those exceptions may actually apply here. So there was a part of my career where I did a lot of work for the Walt Disney Company. And a lot of Disney's counterparts, or certain of them, would go bankrupt. And Disney, just as an example, licenses their characters to various third parties to make shirts and whatever else. So just using it as an example, Disney licenses the company XYZ to produce shirts with Mickey Mouse on it. And they've gotten comfortable, Disney has, with that company, that they're going to use the Mickey Mouse emblem and likeness appropriately. But the company now goes bankrupt. They choose, and then as part of the bankruptcy, they want to sell to another company that Disney may not approve of. So in that situation, because Mickey Mouse is so tied to Disney, the other company that Disney doesn't approve of may, be selling, alcohol or marijuana or whatever else Disney wouldn't want to be associated with. So the bankruptcy code does give a company like Disney in that circumstance a chance to say, no, you can't sell my stuff to a third party. So here, I think there could be some parallels to that because you authors obviously have written these books and they're personal to you. It may be possible if Whitman here did decide to sell your contracts to a third party, it may be possible for you to say no to that and that we're not going to allow that. Again, I would need to do some more research to see how courts have dealt with authors, but it seems to me there is an analogous situation to what Disney and Mickey Mouse here with you guys. So that's certainly a plus if you choose not to allow them to sell. But again, I would need to do some legal research and see what happens. And ultimately, if they did try to sell your contracts, we'd have to object to the bankruptcy court. So we'll see what happens with that. So far, there's been no proposals I'm aware of to sell any assets. So what I do also want to mention is executory contracts. So the bankruptcy code also deals with, as part of a Chapter 11 case, executory contracts. So what's an executory contract? An executory contract is a contract where there's continuing obligations that go both directions. So in your case, in the author's case, you have obviously an agreement with Whitman. That agreement provides for them to publish your works and to pay you, and you're giving them the ability to publish the work and to use your intellectual property. So because there's provisions that go both ways, that would be considered an executory contract. Now, the bankruptcy code has special provisions with executory contracts. The first is where a debtor could choose to assume it. So if you have a contract with a debtor, they choose to assume it, that means that the contract will continue to exist post-bankruptcy in the same form as it existed pre-bankruptcy. As a condition to assuming it, the debtor needs to pay any kind of default under the contract in full. They need to cure defaults. That's the term of art, cure defaults. That means that unlike the creditor who gets paid 10 cents on the dollar in my prior example, in this situation, the debtor would have to pay 100% of what's owed to the publisher. Obviously, that would be great news for the publishers. So if you owed $10,000 and the debtor assumes here, Albert Whitman, to assume your contract, you would then get paid in full, which of course would be terrific news for the authors here. A debtor could also decide the contrary, that is to reject the contract, meaning it no longer wishes to abide by the contract going forward, in which case the contract is deemed to be breached as of the petition date, again, the date the debtor filed for bankruptcy, and the creditor would have the right to file a proof of claim in the bankruptcy or to amend the prior filed claim to set forth how much damages were incurred by the counterpart in the bankruptcy, and then those claims would be dealt with as part of the bankruptcy under the plan. The third possibility of what a debtor can do is assume the contract and then assign it to a third party. This is sort of what I just spoke about a second ago, where it sells the contract to a third party. Again, in most situations, possibly not applicable here, but in most situations, a contractual provision that prohibits assignments, which most contracts have, would not be enforceable. Here, as I said just a minute ago, that is probably, in my view at least, probably not applicable here. So if they did decide to assume and assign your contract with a third party, you'd have the right to either say yes or no to that. And if you didn't want to go to the third party, you could say no. Now, of course, if you did want to go to the third party, that might be a good thing. If you think the third party publisher they're signing to is a good, solid, reputable company that going forward you'd be happy to do business with, then saying yes would make sense. On the other hand, if someone you didn't want to deal with or you thought you had a better shot doing something else, you could say no. The good news, again, if you say yes as part of the assumption and the assignment, the debtor or the third party who's getting the assignment of the contract, they would have to pay you in full for all amounts that are owed. So that's sort of a bonus. If you said no to the assignment, then your contract would then be rejected, in which case you would get paid probably cents on the dollar. So that's sort of a summary of executory contracts. Again, don't know here yet what the debtor is going to do with contracts. Normally, the plan of organization would sort of dictate which contracts will be assumed, which ones will get rejected, and possibly which ones will get assigned. So there's sort of a wait and see here to see what happens. Now, a very important part of a bankruptcy case is creditors asserting their claims in the bankruptcy. There are various ways a claim can get asserted in the bankruptcy. The first is in the bankruptcy case, a debtor will file what's called schedules. And the schedule basically lists every creditor by name with your address and says how much they think you're owed. So they may say that creditor X is owed $1,000. And if you agree with that, and you'll be given a copy of the schedules, they'll send it to you, they'll give you your claim, they'll tell you how you've been scheduled. If you agree as a creditor that you're owed $1,000 in my example, then you're good. You don't need to do anything. You could just basically sit back and not file a proof of claim. However, a couple exceptions to that. There are 3 boxes a debtor can check on their schedule. One is the claim is contingent, meaning it's not necessarily owed. It's owed depending upon something else that happens, meaning the liability is contingent. Or it's not liquidated, meaning no amount's been put down. Or they could list that the claim is disputed. If any of those 3 boxes are checked, then the creditor must file a proof of claim. In other words, if you don't file a proof of claim in those situations, if any of those 3 boxes are checked, then your claim will not be recognized. You'll get 0 in the bankruptcy. Now, the other way to have a claim in the bankruptcy is to file what's called a proof of claim. A proof of claim is basically a 3-page document. It's a form you fill out. Basically, you check certain boxes, fill in certain information, and you can also attach an addendum, which we'll provide to the Authors Guild, who could then provide it to the authors. That proof of claim basically sets forth how much you're owed. Once you file your proof of claim, the bankruptcy code treats that claim as being valid. If the debtor disagrees with it, they have to file an objection to your claim, meaning they say, we don't agree with creditor XYZ that they're owed $1,000. We think instead they should be only owed $800 or $900, or the liability is disputed. If the debtor does object to the claim, then the bankruptcy court will decide who's right, whether it's debtor or the creditor, and dictate how much the claim is owed. My advice always is to file a proof of claim, because if you file a claim, you can always amend it later to, if the amount that you're owed, if you've learned something else is owed, you can amend it to increase it. So you have more control over your claim if you file a proof of claim than if you don't. So my advice to creditors always is file a proof of claim, and the court will set a deadline for filing a proof of claim, well, filing of all proofs of claim. That deadline is known as the bar date. So the debtor will send out to creditors notice of the bar date that the court has scheduled whatever date as being the applicable date by which proofs of claim need to get filed. And they'll give you a sample form, sample proof of claim form you can then fill in. They'll also tell you how your claim was scheduled, whether they did allow your claim in the schedules or not. And again, the bar date is a real line in the sand. If you're a minute late in filing your claim is disallowed. So my advice always is to file a claim early. The debtor has to give not less than, I think it's 30 days notice of the bar date. So as soon as you get the notice, it's always a good idea to file a claim as quickly as possible. Even you don't have to wait for the bar date to get established to file your claim. You can do it tomorrow if you wanted to. Again, I'll talk about this in the context of the Whitman case, but there's no deadline yet set in that case for filing claims. But I do recommend doing it early, again, to avoid having issues with missing deadline, because missing deadline is catastrophic in terms of having your claim allowed. So that's certainly filing it early is always a good idea. You can always amend it later if something happens where the amount changes or you made a mistake or what have you. It's easy to amend the claim, but if you don't file it on time, you're sort of out of luck and you're out in the cold. So filing it early makes sense. So that's an overview of Chapter 11 generally. I'm now going to talk about Subchapter 5 of the Bankruptcy Code, which is the kind of case that Albert Whitman filed. Now, Subchapter 5 came into effect right before the pandemic, so in 2020, and it provides a new way for smaller companies to file for bankruptcy. And again, it's known as Subchapter 5. Filing for bankruptcy before Sub 5 came into effect had become too expensive, too complex, and too time-consuming for small businesses. So small businesses like Whitman weren't really able to file for bankruptcy effectively. It cost too much money. It was too difficult to file. It took too much time. It was way too expensive. So because of all those things, companies like Whitman weren't filing for bankruptcy. They were just going out of business, and it was to nobody's real benefit. So a commission of bankruptcy professionals came together to look for solutions to this issue. They came up with a recommendation, which basically then became Subchapter 5, which Congress, as I said, passed right before the pandemic. And it has been a resounding success. It has been a great addition to the bankruptcy code for smaller companies. It's really resulted in companies being able to get out of bankruptcy more quickly, much more cheaply, and offer streamlined cases for these small companies. So the amount of debt that what's considered a small company has changed over time. During the pandemic, it went up to a larger amount, about 7,500,000. Unfortunately, it's come back down again to pandemic levels. But here, the Whitman Company did have a sufficiently small amount of debt to file for Subchapter 5. So they're taking advantage of those provisions, which are good for them. It's also good for creditors as well, because it enables the debtor to spend their money and their time getting out of bankruptcy more quickly, which means a better recovery generally for creditors. So what are some of the differences between a regular bankruptcy, a non-Subchapter 5 bankruptcy, and a Subchapter 5? First off, in a Subchapter 5 bankruptcy, there's no creditors committee. So usually in a larger case, a larger bankruptcy, Chapter 11 case, the U.S. trustee puts into place what's called a creditors committee. The creditors committee is made up of usually 7 creditors who come together and fight for the interests of the unsecured creditors. Sounds like a great thing, and it usually is, it can be, but it's also quite expensive because the creditors committee is going to hire their own attorneys, their own other bankruptcy professionals like financial advisors, investment bankers, and other people, all paid for by the debtor. So what happens is the debtor, in addition to paying for its counsel and its restructuring advisors and its bankers, also wind up paying for those for the creditors committee. And in a small case, like a subchapter 5 case, it was felt that a creditor committee didn't need to exist, that there were enough other avenues available for creditors to make their voices known. And I'll talk about that in a couple of minutes. That a creditor committee wasn't required. So rather than waste potentially hundreds of thousands of dollars and millions of dollars even on a creditors committee, it was thought that those amounts could better be spent on paying creditors. So there's no creditors committee in a subchapter 5 case. There is, however, something called a subchapter 5 trustee who gets appointed. And he or she has a really pivotal role in the case. They basically come in as a party to facilitate the restructuring, to facilitate the process. And they are not representatives of the creditors per se, but they can do certain things that are akin to what a committee would do. So basically, they come in, work with the debtor, work with other parties to facilitate the process, to make sure the process is going well, make sure it's going in accordance with the bankruptcy code, to basically ensure that the case proceeds appropriately. So they are people who are trained, and they do a quite good job in most cases of trying to facilitate the process. In a regular bankruptcy case, there's a period of time after which any party can file a plan of reorganization. In a sub 5 case, only the debtor can file a plan unless the court says otherwise. That's another change from a regular process. Now, the requirements for a debtor to confirm a plan in a subchapter 5 case are also much easier. I'm not going to go into a lot of details on this, because it's sort of inside baseball, and it doesn't necessarily get a whole lot of resonance for non-lawyers, but the process of getting a case confirmed under the bankruptcy code under sub 5 is easier. And that could either be good news or bad news. The good news is it's more likely a case or plan will get confirmed. The bad news is the creditors don't have as much of an ability to object to the plan if they don't like it, or to vote against it if they don't like it, as they would in a normal Chapter 11 case. And again, that's where the sub 5 trustee comes into place, to sort of work with the debtor to come up with a plan that makes sense for everyone. Now, the timing of a sub 5 case is also significantly more quick than a normal bankruptcy case. I've been involved with bankruptcy cases that have gone on for years and years and years. The Purdue Pharma case is now in its 6th year. I've been involved in bankruptcy cases that have gone even longer than that. A sub 5 case goes relatively quickly. The debtor is supposed to file a plan of organization within 90 days of filing for bankruptcy. So that can be extended, but in most cases, the court won't extend it very long. But again, the goal here is to get it in and out of bankruptcy relatively quickly. So the goal here is to get the case, get a plan filed quickly, again, within 90 days if possible. There could be a short extension if certain conditions exist. Things are sort of happen outside the control of the debtor. The court can extend it for a period of time, but usually it's not a very long extension. Now, the plan also must provide, and this is also a change to what a normal bankruptcy case would provide. Usually in a Chapter 11 case, the debtor will give whatever assets it has to creditors. Here, the plan under sub 5 case must provide the future earnings, the future income. A portion of that must get paid to creditors going forward over a period of 3 to 5 years. The plan will say that creditors will get X dollars, X percent of our future profits, future revenue going forward, future income over a period of 3 to 5 years. And that, again, the creditors will vote either to accept that or not. So it does provide more than a regular Chapter 11 case for payments over time, again, over a period of 3 to 5 years. So that's sort of a summary of subchapter 5. Against that backdrop, I'm going to talk about the Arthur Whitman case for a few minutes, then I'm going to open it up to questions. I see there's a bunch of questions already. And I've gotten questions before the webinar started. So the Arthur Whitman case, they filed for subchapter 5 bankruptcy on April 22nd of this year with the bankruptcy court in Illinois. So under the 90-day period I just spoke about, they're supposed to file their bankruptcy plan by July 21st. They have about a little less than 2 months left under their 90-day period. to file their bankruptcy plan. Again, I don't know what their plans are at this point in terms of where they are in the process. We'll learn more about that on Thursday. I'll talk about that in a second. But I suspect they'll file a plan on or around July 21st. Again, they could seek a small extension if they think it's required under the circumstance, but the case should proceed relatively quickly. The debtor last week filed their schedules. I mentioned before, the schedules list all creditors in the case and say how much they're owed. They will send this at some point out to the creditors, out to you all, to tell you how much they think they owe you. And again, you can either agree with that or not. Ultimately, the bankruptcy court will set a deadline, as I mentioned earlier, to file proofs of claim. There is no deadline set as of yet. I would expect a deadline to be set relatively soon. It'll probably be in July, I would assume at this point, although again, there's no deadline yet. So once there is one, I'll let the folks at the Authors Guild know. They'll let you know. But as of today, there is no deadline. And as I said earlier, I would definitely recommend that all creditors file their claims sooner rather than later. It's a 3-page form. Again, you fill in certain information. I'll highlight to the Authors Guild and provide instructions about how to fill that out, which boxes you need to think about checking. You need to sign the form. There'll be an address to send it to, and you'll send it into the address, and your claim will be recognized. There's also an addendum that we tend to put, next to our proofs of claim that we prepare. I'll provide an example of that to the Authors Guild as well, and they'll, I'm sure, share it with the authors, so you could use something similar as well. Again, once a proof of claim is filed, your claim is deemed allowed. So it means you'll have a valid claim until unless the debtor says, I disagree, by filing an objection. So that's how you file a proof of claim. Again, I can't emphasize this enough. Do it early. If once the bankruptcy court sets a deadline, if you miss a deadline even by a minute, your claim is not allowed. You'll get nothing in the bankruptcy, and it will be a bad situation for you. So file a claim early to make sure it doesn't happen. So the final thing I'm going to talk about before opening up the questions is on Thursday, meaning 2 days from today, there's a 341 meeting. So what is that? A 341 meeting, a 341 section of the Bankruptcy Code that requires the debtor to submit to an examination by creditors. So the 341 meeting on Thursday at 1:30 Central Time, and note that's Chicago time, not New York time, the 1:30 Central Time, all creditors are invited to attend. There will be someone there for the debtor, a representative who will swear under oath, be sworn in under oath, and he or she will then answer questions. It could be the U.S. trustee asking questions. I'm sure that the Chapter 5 trustee will likely have some questions. And then it'll open up the floor to anyone who wants to ask any questions. So it could be anyone on this call, anyone else who wants to ask questions. The floor will be open to ask anything you want. Now, the one caveat is you can't ask questions about your claims. You can't say, I'm creditor, I'm a book author, I have a claim of $10,000. Do you agree with that? They won't answer questions that are specific to creditors, specifically, but they will answer questions generally. So they might be asked about how they plan to file their plan, what their timing is going to be, if they have any kind of preliminary thoughts about what the plan is going to say. And again, whoever's there for the debtor will be required to answer under oath those questions. The meeting scheduled at 1:30 Central Time on Thursday. It will go for about an hour. If there are lots of people asking questions, it may go longer, or they may continue it to another day. I certainly would encourage folks to attend. I should also mention, I should have mentioned this earlier, that meeting will be held over Teams, so it's going to be a virtual meeting, so anyone can attend from anywhere they want. I have provided to the Authors Guild information on how to access that meeting. I'm sure it'll circulate it after this call. I would say it would be good if people attended that. It will certainly show the Subchapter 5 trustee, show the debtor. There's lots of interest in the case, lots of interest in what happens, how people's contracts and their books are dealt with. So I think it's a good idea to attend if you can. Again, it should last about an hour on Thursday, and you will have a chance to ask questions. Any kind of questions you have for the debtor, you can feel free to ask. Again, not specifically about your book or your claim, but general questions will all be fair game. So with that, I'm going to open it up for questions. I see we have a ton of questions, so I'm glad I left some time. So how do we want to do this? Demir, do you want to?
Yes, I can start with the questions.
Sure.
So one of the questions that we got a lot of is Albert Whitman in some cases has been delinquent in rendering statements for like a couple of years, so authors actually have no idea what they're owed. Um, and so how would that work if you're filing a proof of claim? Can they estimate what they're owed?
Yes, that's a very good question, and that's a question certainly you should ask also on Thursday, or the author should ask on Thursday at the 341, sort of how to deal. Why is there been a lapse in sending out statements?
Mhm.
But the answer is yes, most certainly, folks should estimate their claims um, as best as they can. Now, you're filing your proof of claim under penalty of perjury, so you don't want to say I'm owed $10 million if you're really owed $1,000. But certainly in the addendum, you can say that because I've not gotten statements, this is my best estimate of claims. As long as you're in good faith, setting
Mhm.
forth what you think the claim is worth, filing under penalty of perjury is fine. But I would go higher than lower in terms of your estimates because it's easier to negotiate downward with the debtor than to negotiate upward. So I would put in a fair estimate, but a reasonable one.
Okay. Thanks. That's really helpful. One of the questions that I've gotten also is, they're supposed to abide by the contractual terms and to render statements and issue royalties post petitions in due course, but
Yes.
they haven't really done that. And is there any way I mean, because their practice in the past has also been of like delinquency. So, is there any way the authors can guarantee that this happens at least post petition? For instance, for statements that are due now. Um, yeah, is there any way that they can enforce that?
So the answer is yes. There are various ways to do it, some of which are probably going to be too expensive to really be practical. So, certainly a debtor who's not adhering to its obligations post bankruptcy, post petition, a creditor can go to the bankruptcy court to either file a motion to dismiss the bankruptcy case or to convert it to a different kind of a bankruptcy case or to require them to comply. But filing a motion with the bankruptcy court is not cheap, nor is it easy. So you can do that. If someone was owed a lot of money, that might make sense for them to do that. But I'm guessing most people are not owed that much, so it may not make sense. But also creditors can get together and do it, on behalf of 10, 20, 50 creditors to make it more economical.
Mm-hmm.
Another thing that creditors can do, and this is one thing I would suggest, is reach out to the subchapter 5 trustee. They said it's his job or her job. Here, I think it's a gentleman who has the job to liaise with the debtor and to make sure they're doing what they're supposed to do. So
Mm-hmm.
hopefully, if people are finding that are not being doing what they should do post petition, reaching out to the sub 5 trustee, and I could let you know who that is after the call. Reaching out to him or her, and they'll also be present there on Thursday. Reaching out to him or her will also help to hopefully cause him to say that to the debtor, look, you need to be doing this, or else I'm going to move to dismiss the case.
Mm-hmm.
Again, I'd also bring that up on Thursday because that's a good opportunity to raise the issue with the debtor, with the sub 5 trustee, so they know there is an issue with the debtor performing or not performing post bankruptcy.
Got it. That's really helpful. Let's see here. Okay, so we will send out information on attending the 341 hearing, and I encourage everyone to attend and ask questions. Looks like we have covered the okay, so this is a question about sublicenses. I know we've covered automatic reversion, but Joanne Oppenheim, hey Joanne, in our case, Whitman granted a sublicense to another house. They were paid. We were not. The contract with Whitman had an automatic reversion on bankruptcy provision. Does the sublicensee lose its license? Um, do we get the rights back?
Yeah.
Yeah.
All right. So first off, and I got one of the questions I was given pre webinar as well, is whether you can include a clause in a contract that basically says upon a bankruptcy, the license automatically terminates. The answer is you can include the clause. That the bad news is it's not effective. It's
Yeah.
called the bankruptcy code just overrides that, called an ex post facto clause. The bankruptcy court, the bankruptcy code rather, overrides that provision. The automatic stay says you can't enforce it. People still include it anyway because there could be a change in the law, but I wouldn't hold my breath. So you can include the clause, but it's not effective. But the question you asked is a little bit different. So what happens with a sublicense? So essentially, if I'm understanding your question, the author licensed the book to Whitman. Whitman then sublicensed to another publisher to actually publish it. So it really is subject to what Whitman does in the bankruptcy. Does it assume both the license and the sublicense, or reject one or both of those? If they were to reject the license, then the sublicense goes away automatically because you can't sublicense something you have a license to. So if the license of the author goes away, the sublicense would go away as well. Theoretically, it could assume the license, but also still reject the sublicense, meaning that at that point, the right to publish would go back to Whitman post bankruptcy if they assume the prime license and reject the sublicense. Now, if again post bankruptcy, the amounts that are owed from the sublicensee to Whitman and then to the licensor should get paid in the ordinary course. So if they're not getting paid, again, I would reach out to the sub 5 trustee and make him aware of that and ask him to look into it. Hopefully he would do that.
Really, really helpful. So we answered this about like how do you make a claim if you don't have royalty statements. So one question that I had was I saw the notice for the 341 hearing. It had a list of creditors, but it didn't have the authors listed in it. And I know that you have seen the schedule, so I'm just wondering, like, I mean, they're legally required to list all of the authors with pending contracts as the creditors, correct?
They should be. Anyone who, I mean, the bankruptcy code provides quite clearly that anyone who's owed money by the debtor, they're required to schedule. Now, oftentimes, to be perfectly honest, debtor, their record may not be perfect, or they may be far from perfect, which is why they got into financial trouble in the first place. So there's always situations that certain creditors are excluded, hopefully inadvertently, but they're excluded. Which is why it's really important then to make sure all the authors actually get the notice. And usually, in many situations, they'll also publish notice in some kind of a trade journal or newspaper to give constructive notice. But if they have actual notice that publisher John Smith is owed money, they're required to list him in the schedules as being owed whatever they think that he or she is owed, and then to give actual notice of the bar date to those creditors. But again, it's not wise to rely upon that because mistakes are made, and there can be situations where you can get relief from the bar date. But again, that's a time-consuming, expensive process that it would be best to avoid.
Okay, so if we get a hold of the schedule, can we publish it on our website and ask authors to?
Yeah, I can send it to you. I'll pull it from the bankruptcy court and send it to you.
Okay, sounds good. If the authors decide to object to sell any contracts to someone else, is that a joint objection for all authors through the guild, or will authors individually object?
I think I can get that another way. I mean, each author is required to object to his or her own contract being assigned, but there's nothing that says authors can't get together and file a common objection if they all have the same grounds for saying no. So the answer is they can do it separately. We also don't see any reason why they couldn't do it collectively.
Got it. And then if there is a no assignment clause, the bankruptcy plan would still override that, right?
In most cases, yes. So in most cases, the bankruptcy would override a no assignment clause. But as I said earlier, here, because the intellectual property is sort of tied to the authors, there are exceptions for those situations. Again, I have not seen cases dealing with authors specifically, how bankruptcy courts have looked at that, whether that's a personal service contract, which is what you can't assign over someone's objection. But I certainly see how an author's work, their work product, their book, their illustrations, whatever it is, would be so personal to them that to have it go to a third party they object to would be unconscionable and ultimately illegal.
Yeah.
So like the Disney situation where Disney wouldn't want to have Mickey Mouse, hawking, you know, Miller beer.
Yeah.
An author could say, I don't want to be aligned with this publisher who doesn't share my values, doesn't share my vision of how the publishing should happen, et cetera. So
Hmm.
I would think there's strong parallels. If we were to get in that situation where we had to object, I would need to do some more legal research to ensure that's in fact the case. But I do think it would be the case given the general law as it exists.
Okay, and because the contracts also have, yeah, the no assignment clause,
Right.
uh, Albert Whitman contracts too. Um, let's see. If we're agented, would this process for filing proof of claims all happen through the agency? Um, I think the literary agent can, like, if there's a literary agent, they can intercede on behalf of the authors.
Yeah, I mean, the proof of claim would need to list who the author is, but if you have an agent, they
Yeah.
can file, assuming that they have the authority
Yeah.
legally to file the claim, meaning that there's an actual relationship between the author and the agent. The agent can file a claim on behalf of the author and be the representative. So,
Because, yeah, go ahead.
I was gonna say, so sometimes as a lawyer, I can file a claim on behalf of a client because I'm their agent for that purpose. So I can file the claim on their behalf, and it's a perfectly valid claim.
Yeah, because in many publishing contracts there is an agency clause whereby the agent collects the monies on behalf of the author, but the rights still
Right,
belong to the author.
right, right. Yeah, I wouldn't see any problem with the agent filing a claim there.
Okay,
Again,
so
subject to what the actual contract says, but it sounds like what you're describing as a situation that would be appropriate, would
yeah,
be appropriate for the agent to file a claim.
that makes sense. So authors, if you have agents, definitely let them know, let us know, or like uh, ask them to contact us, and we can also provide clarification on the proof of claims. But they might be able to, file it on your behalf. So one question that has come up a lot, and I mean, now in some ways, bankruptcy does offer transparency, but for many years, authors just have had serious concerns about the accuracy of Albert Whitman's accounting and reporting.
Yeah,
Uh, I mean, I've been involved in situations where tens of thousands of dollars were owed that after we pressed them and they went back and looked at their accounts, they were finally given. So I guess I mean, I think that the is there any way, I mean, whatever they're stating as the claims, they're stating under penalty of perjury, but is there any way for authors to compel them to release their accounting, or if they have concerns about the accuracy of their accounting?
yeah. I mean, certainly the author could ask, and again, it's a question I would ask on Thursday
Yeah.
About the process by getting the data that underlies
Yeah.
the statements.
Yeah.
There are ways to do it. Again, they can get expensive in terms of going to bankruptcy court to seek relief. There's
Hmm.
something called 2004, the Bankruptcy Code, that enables a creditor to depose a debtor.
Hmm.
So you can get very liberal discovery from a debtor on
Hmm.
their operations. But again, that does require going to court to seek to invoke this provision of the bankruptcy laws to allow the examination. Then, of course, it requires someone to actually examine the debtor. So
Hmm.
it can get expensive to do that.
Hmm.
Don't know if it's worth it or not, but hopefully, if the issue is raised on Thursday, the sub five trustee can encourage the debtor to be a little bit generous in terms of the record it gives to
Hmm.
substantiate claims.
Okay, that's good to know. And I'm also wondering, like, some of these things can be done sort of on behalf of a class, right? So if the Authors Guild could representing all Whitman authors could possibly like intervene, and it would be expensive for us too, and we would have to look at.
Yeah, so it's definitely be economies of scale to creditors proceeding collectively or even having the Authors Guild do it on their behalf. I guess the problem is if there's 1,000 authors who owed money, it'd
Yeah.
be really kind of tough to depose someone on 1,000 different situations. So we'd have to figure out a sort of a more a process to do that.
Yeah.
It may be more documentary than actually getting to a room and deposing somebody.
Mhm.
But we could think about, if that's something you want to think about, we could think about ways to make that more efficient.
Okay. One question that I had in a situation that I was dealing with, there was an author who was negotiating a rights reversion from them for a while, and then we finally agreed on terms over email. But we hadn't signed the actual document. My understanding is, and that's pre-petition because that happened before the petition.
Right.
Um, so we should be able to get that outside of bankruptcy, get the rights reversion because we agreed on all of the terms.
Yeah, so for street petition, it's going to be hard to do it now. I mean, if they still want to agree to that, the debtor post
Yeah,
petition, they may need to get bankruptcy court approval to do it.
got it.
But if everyone agrees on the terms, everyone thinks it's in everyone's best interest to do it. There's
Yeah,
no reason they should not want to do it post bankruptcy.
yeah,
But it really is a matter of the debtor has some more optionality there because it's now something was agreed pre-petition, it's now post petition, so it didn't happen pre petition. I guess
right.
the other question is, and I haven't seen obviously the emails.
Mm.
The emails themselves were the agreement. It
Yeah,
might be possible to say we had an agreement. This is the agreement. The emails confirm it.
yeah,
In other cases, the emails might say that subject to documentation, we're
yeah,
going to agree to this. So it really depends what the email said and what the
yeah.
email was.
And yeah, that's our argument that the emails actually formed the agreement because they
Right.
offer an acceptance pretty clearly. So okay.
A couple
Uh
of questions I saw, I could address them a
yeah,
little bit.
yeah, that'd be great.
Yeah, so one of the things that the questions I got pre-webinar was, yeah, how do you know before bankruptcy that your counterpart is having issues to sort of prevent some of the problems that may come up in a bankruptcy? Uh, the bad news there is that there's no surefire way to know that. Some of the signs that you might see are a counterparty not paying on time, where they always paid on time in the past, not giving you good answers, trying to steamroll you, trying to not give you documentation. But really a change in behavior of how they operated, for the last 5 years, and now they're sort of acting differently. Um, might be a sign that something's up. But there's no surefire way, unfortunately, of trying to say, okay, this is the smoking gun, so to speak. That means I'm going to file for bankruptcy, next week or next month. But generally, I'd look at sort of has their behavior changed over time without any kind of good explanation. Now, it could be, something happened that does cause them to get behind, or something happens to cause them not to be as forthcoming with records that is perfectly legitimate. But always look at that, I would say, with a skeptical eye, and see, is that really the answer? That's really the reason they're giving for that. That really sort of the reason for what's happening. And if you see changes in behavior, that's sort of a red flag to sort of put your ears up and sort of become a little cautious, I would say. Another question I was asked is, what happens if a publisher just closes the stores versus going bankrupt? Again, unfortunately, not a great answer here. So there are situations, many situations. In fact, I think most companies that go out of business just shut their doors. In that case, you can sue the company that shut its doors, but usually, in many cases, suing them will not provide all that much relief because they're out of money. So you're sort of, not very effective in doing anything. So unfortunately, in most cases, the doors just get shut. There's not much that can be done to really, get a recovery. Again, people getting together to act collectively could be a situation. You could file involuntary bankruptcy. That's a whole different can of wax. We basically put the company into bankruptcy, and then you have a more transparent process. But again, there are issues associated with that. But unless you think there's sort of a pot of gold at the end of the rainbow where you can get something from the company that closed its doors, bankruptcy itself won't actually provide value. It may actually, do nothing to get you any kind of recovery. So unfortunately, in the vast majority of cases, the companies that shut their doors, there's not a lot of stuff that people can do.
Okay, let's see. I think we have answered. Yes, so a couple of things. Yes, we will send out a follow-up email, one with the information about the 341 hearing. The meeting will be recorded and we'll follow up when the recording is available.
Yeah, I
Three,
don't. They
yeah,
may prevent you from recording it on Thursday. They will record it for sure,
uh-huh.
and they may provide it or not. But I think they're not going to allow you to record it.
Oh, got it. I meant the recording of this webinar, but
Oh, sorry. I'm sorry.
the recording of the 341 hearing may not be um available. And then one question that came up was, how do you, so if the bankruptcy, if the reversion clause is not effective in bankruptcy, how do you protect yourself? And I would just direct authors to look at the Authors Guild model contract, because we have language in there in the royalty section that says that you can get your rights back if the publisher is delinquent in rendering statements, within 1 year, and or something to that effect. Which essentially means that before the publisher files bankruptcy, you already know that they're in bad financial health because they're not rendering statements, and that could be construed as a material breach of contract that allows you to get rights back. So that's
Yeah,
one way to protect yourself.
yeah, absolutely. So before the bankruptcy gets filed, this is the breach of the agreement. You can take your rights back, which is why it's very important. Now, they said just a few minutes ago, if you see situations changing, their behavior changing over time, that's a red flag, and you should pay attention to that. And if your contract provides that that's material breach, not paying you or not giving you records, if you terminate your contract prior to a bankruptcy, that's perfectly fine. And that at that point, when they go into bankruptcy, they don't have your contract anymore to be part of the bankruptcy. So it's a big decision to make whether you want to terminate. There could be consequences to that as well. But if you can terminate pre-petition and you determine it's appropriate to do that, doing that does make sense if you have the legal right to do it. So absolutely, I think that's a perfect answer.
So in terms of rights reversions, right now, since the bankruptcy is ongoing, you cannot ask and get a rights reversion, and it's up to the publisher whether or not they assume the contract, which is continue the contract, or reject it, in which case you will get your rights back. So
Right.
we won't know that for a while.
Yep. That's right. And again, there may be circumstances where you can approach the debtor and say, hey, I want to get this back. Will you consent? And they may be fine with that, but may not be. It really depends upon what the debtor's plans are. And again, we'll learn more about that, I think, on Thursday at the 341, sort of what the bankruptcy is going to look like in terms of a plan.
Yeah.
Are they going to do their own plan? Are they going to sell their assets? Are they going to continue operating? What's the timeline? What's the payout going to be? If they know yet, sort of what their plan is. And they'll also have to talk about on Thursday, frankly, what caused the bankruptcy. Why is it that they went bankrupt? What happened that affected their business, that they went from being a solid, profitable company to one that's no longer profitable? And maybe you all know the answers. I personally don't. But if there's a story there to be told, I would expect them to tell it, and they're also going to detail ultimately through the bankruptcy how they hope to get back to financial health, and how they hope to be a good, profitable company, hopefully going forward. Which again may be the best answer for everyone here, that if they can get back on their feet and start doing well prospectively, hopefully the contract that you all have with them will survive the bankruptcy and then provide years of good support to everyone.
Sounds good. And yes, so there's some questions about the proof of claim. We will help authors file it. You should be notified. We're gonna get the list of creditors and make sure that if you're not on there, to get on there. And then yeah, we'll be with Marc's invaluable assistance. We'll be monitoring this case and helping authors. So I think we're out of time. So if you have any other questions, send them into staff@authorsguild.org, or use our legal help request form if you're an Authors Guild member. And we'll follow up with the notice of 341 hearing. And I highly encourage everyone here to attend.
Great. Well, thank you so much. I enjoyed this afternoon. And if you have any other questions, as was said, submit them, and I'm sure they'll reach out to me. So thanks, everyone.